A very good evening, everyone. I am Vishalakshi and I am your faculty and mentor for Livelaw Academy for the course on Judiciary examination course. And today we are going to start with the topic of private defense. As I have told you in my previous lecture, general exceptions is a very important question which comes in your papers in both categories, whether it is in a descriptive form or in a MCQ form. So I hope that I'm able to give you an overview. I have split this particular lecture into two halves. That is the first half, which will be more intended towards the basics that are involved in this particular concept. And then we go into the more detailed sections in the second part. So I hope that I'm able to give you some clarity on these topics. Just in a moment, I'll share my screen. Right. So the first half of this particular concept or topic, which is split into, a set of 10 sections, where the first half elaborates on what are the basic concepts of private defense, and it then splits into very definitive parts of these sections. Today, we deal with the basic principles that are involved in private defense. So sections 96 to 106 of IPC deal with this, and they have been incorporated in the BNS from section 34 to 44. Now, your first section is interesting because it is just simply a declaration. It is stating that nothing is an offense which is done in the exercise of the right of private defense. So, nothing is punishable which is done in the exercise of your right of private defense. So, private defense is a right we enjoy. Now, what type of right is private defense? The term used is that this right is defensive in nature. What do you mean by defensive? That you are responding, you are defending, you are actually in a situation where someone has done something to you, and therefore in that situation you have no option but to defend. You have a no option but to do something to try to protect yourself. So this is a defensive right. It is neither a right of reprisal nor of aggression. What does this mean? You can not be the individual who is creating the aggression. You should not be the individual who is maybe starting the aggression. You are the individual who is basically in a position where an aggression has taken place with you, and you are sort of defending yourself from that aggression. And mind you, that is not a retaliation. Retaliation and defense are separate things. Retaliation is that there is a perspective of anger to it. You're retaliating because X did something, so I'm doing so. But this is not the case. In this situation, X is doing something to me, so I have to do something in order to protect myself, is the mindset behind your right of private defense. So it is not retaliative, it is not aggressive, it is defensive. You are in a position where you have no option but you are responding to a certain situation, right? Now, why do we as individuals have a right to private defense? Basically, something wrong is happening to you, and you have this right where you defend yourself. Because while we are told that we are protected by the government, there are public authorities that are established to take care of us. But is it possible for those entities to be available at all times and immediately when we are in the face of danger? In that position, most often they are not available, and it's not possible for them to be available. And therefore, in those circumstances, we have this particular right available to us, and we as individuals are expected to also in some case, in some sense, to protect ourselves, to preserve ourselves, and to defend ourselves. So this is why we as individuals are given this right, because the state, its authorities are not available immediately and at all times. There may be an occasion that we are in the face of a threat and we have to defend ourselves. So first section that we deal with, the primary section: nothing is an offense which is done in the exercise of the right of private defense. The right of private defense, defensive right, not aggressive. It's not a right of aggression or reprisal or retaliation. It is the right to defend. It is available to us. Why? Because we are sometimes in positions where authorities are not present and we have to preserve or protect ourselves. So immediately we come to this particular case. And the reason we come to this case is because it elaborates a lot about what is the right of private defense. So before I go to the case, what I'd like to do is discuss this case in short. There are two people, A and B. They have a premises. The premises has a business and I think it has their dwelling also. And there is a bandh and some kind of riot, some kind of um, situation is on, wherein many properties and many individuals are entering into properties, shutting them down, causing some kind of disharmony, causing some kind of destruction. So on this particular bandh day, they come to this place also. They manhandle workers who are here and they shut down and destruct and try to destruct this particular premises of A and B. Now, A and B somehow shut down this place and go on top, on an above floor, and from that place, they use, for some reason, they see that on the gate near the gate, these individuals who were causing all this disharmony during the bandh are there, and A, who is the son of B, fires at them, right? And two individuals who were these miscreants who were causing all this disharmony, now they die. Now, what is the debate? A and B have a premises, yes. A and B's premises is forced shut. There is some, they manhandle people in their shop, and many such wrong things have happened. A and B go up, A and B, out of A and B, A shoots and indiscriminately, out of which two people pass away. The question comes is that, is the right of private defense available to A and B, because they were at somewhere near the outside their premises, close to the gate, somewhere these two people, two, three people were there, right? So do they have a right of private defense still when that individual is not in actually inside your shop? The shop has been shut down. So this debate came in. Now we have a further discussion on this while we look at the case law. At the start of the case law itself, you see a very interesting set of statements which I have highlighted. Self preservation is the primary, just a minute. Self preservation is the prime instinct of every human being. The right of private defense is a recognized right in criminal law. So it highlights on the part that self-preservation is the prime instinct of individuals. Therefore, Section 96 of IPC provides nothing is an offense which is done in the right of private defense, right? It is a right of self-preservation. The question is, as happens in many cases, where exercise of such rights is claimed, whether the Lakshman Rekha applicable to its exercise has been exceeded. So again, we come to this point as to whether there is right of private defense in this case. These people were somewhere outside their property. These two individuals were on top and they shot. is there an exceeding of right of private defense was the question that came in. This is some of the facts which I have highlighted. Now, while the court is discussing, you can see that they highlight some important facets. So, the court has said that the section does not define the expression right of private defense, right? It merely indicates that nothing is an offense which is done in the exercise of such right, whether in a particular set of circumstances a person legitimately acted in the exercise of right of private defense is a question of fact to be determined on the facts and circumstances of each case. No test in the abstract for determining such a question can be laid down. In determining this question of fact, the court must consider all surrounding circumstances. So, what it highlights is right of private defense is available, but it is not defined per se. Every fact, every circumstance of each case has to be identified, and on the basis of which one can determine whether there is a right of private defense or not. Right? Now, further again, the court has highlighted Lakshmi Singh versus State of Bihar's case and states that a plea of right of private defense cannot be based on surmises and speculation. While considering whether the right of private defense is available to an accused, it is not relevant whether he may have a chance to inflict severe and mortal injury on the aggressor. In order to find whether the right of private defense is available to an accused, the entire incident must be examined. So it cannot be based on speculation, it cannot be based on what one or two people say. It has to be based holistically on what each one or each and every facet of that case results in, right? So the right of private defense is essentially a defensive right circumscribed by the governing statute, that is IPC, available only when the circumstances clearly justify it. It should not be allowed to be pleaded or availed as a pretext for vindictive, aggressive, or retributive purposes. Now, this is important. It is no retribution means revenge. So, defense or private defense is not revenge, it is preservation, it is a defensive right. And as we had discussed previously, it is again highlighted, it is a right of defense, not of retribution, expected to repel unlawful aggression and not as a retaliatory measure. It is not a retaliation, it is an act of defense, right? So we see that in this particular case, the court said in the circumstances, the inevitable conclusion is that the acts done by the accused were in reasonable limits of exercise of his right of private defense, and he was entitled to the protection afforded in law under section 96 of IPC. So it meant that in this case, the court took into consideration that there was a band. The court took into consideration that there was a lot of destruction happening. Another thing that they found was there was also explosive material with the victims, right? The people who were there, who were causing all this disharmony, they had explosive material with them and they had tried also to cause more harm. So, in such scenario, the court felt that these two people were justified. They felt that they were under a lot of threat and they have a right of private defense, and felt that in such situation they should fire from where they were because they felt that they or their property were being harmed at that point of time. So just to recap, this was the James Martin case, and in the James Martin case we have seen that there was an individual who basically has lost some or has faced some loss of property, and therefore he responds, he tries to defend his property. Two people pass away. Court says that there was a right of private defense, and also re-establishes certain important points like that it is a defensive right, and that it is not a matter of retaliation or retribution. Now, elaborating further on this part, I have just highlighted a relevant part of Surjit Singh versus State of Punjab. It states that it is important to bear in mind that self-preservation of one's life is the necessary commitment of the right of life enshrined in Article 21 of the Constitution of India and is fundamental in nature, sacred, precious, inviolable. The importance and validity of the duty, it is a duty and right to self-preservation has a species in the right of self-defense in criminal law. So the constitutional perspective is also given that our right of private defense is not only something which is a subset of self-preservation, but a hint towards the fact that it is not only a right, but may also be our duty. And we will discuss about this further as we go ahead. Coming to the concept or the aspect of burden of proof in such cases, as I have discussed in the Unsound Mind lecture, if you have followed it, that under the Indian Evidence Act, it is required that all general exceptions have to be proved by the individuals who are taking that particular plea. But what is also clarified is that they have to create a reasonable doubt, that is as much as what is required from them, that they should create a reasonable doubt and a preponderance of possibilities, which means that the most probable outcome is that this was an act of private defense. So even if we take the Martin case, they have exposed the facts of the case, they've shown the circumstances which create reasonable doubt, and that all in all probability what those two individuals did was an act of private defense. That is all that the court says is required to be done by such an individual who takes the plea of private defense, right? Now, if in a case the accused has not taken the plea, but from materials found, it is seen that there may be a plea available. It is open to the court to consider this particular aspect, that there may be private defense which may have been used by the accused and must be taken into consideration in that particular case. So, burden of proof under 105 of Indian Evidence Act or of Section 108 of BNSS is that they have to justify, they have to create that plea, but only to the extent of reasonable doubt, and preponderance of possibilities must be established only up to then. And in case it is not pled by that particular accused, even the court can consider such a case. It can base it on the materials that they have found. Just some simple MCQs which have come in your papers. The right of private defense is based on the natural instinct of self-reliance, self-respect, self-sufficiency, or self-preservation. Very easily, as I have already explained, it is based on self-preservation. Another question asked is, the right of private defense is not a right of defense but of retribution. No, this is wrong. It is not a retributive right. A right of defense, but not a right of retribution. This is looking like the correct answer, but let's see the other ones. A right of defense as well a right of retribution, wrong, because it is does not involve retribution. Is neither a right of defense nor a right of retribution, wrong. So we come back to this. It is a right of defense, but not a right of retribution. So some simple questions which have been asked, if you are clear on the concepts, you will be able to easily answer. Right? Moving on, so we have now just dealt with the fact that what is private defense, what are the rights available, how it came into being, and what is the nature of this right, right, and how it is viewed from many perspectives, right? Now coming to the next section, which gives much more clarity on what the right of private defense is. It clearly now diversifies private defense into two types. And as we read, we'll discuss further. I in This is in section 35 of BNS. Every person has a right, subject to the restrictions of section 37, which we will discuss, to defend his own body and the body of any other person against any offense affecting the human body, the property, whether movable or immovable, of himself or of any other person, against any act which is an offense falling under the definition of theft, robbery, mischief, criminal trespass, or which is an attempt to commit any of those offenses. So, what do we now understand? That the right of private defense is available if an offense is committed against the body of yourself or of any other individual, or an offense in relation to movable or immovable property in context of the limited offenses that are mentioned here, which is theft, robbery, mischief, or criminal trespass, or an attempt of any one of these. So we now know that the right of private defense is available not only against body but also movable and immovable property, and also the fact that it is not only available against yourself, but that body of another and also the property of another could be involved, and you can continue to defend those individuals, right? So the section creates, just for simplicity, I have created a table where you can see, in case of body, you can protect your own or of any other person from any offense affecting the human body. Same way, in case of movable, immovable property of yourself or of any other person. And in this situation of these limited offenses or an attempt to commit the same offenses. Now, please look at these offenses carefully: theft, robbery, mischief, and criminal trespass. While the section is clear that you can commit you have the right of private defense against movable and immovable property, an important question is it necessary for you to be the owner of the property? Only then can you defend that property? Is that really necessary? The answer is again in the section. When you look at these offenses, what you see is somewhere more than ownership. What is necessary is that you should be somewhere in possession of these properties. For example, if somebody is stealing my purse, I have it in my possession, and so will I try to defend it, right? Defense in itself is a physical action. So when it is with me, only then can I go and try to defend it. Another simple way of putting it forward is also criminal trespass. When I'm present there at that place, only then will I be able to defend that particular trespass that is taking place with me. So, what I'm trying to say is that possession is important when it comes to the right of private defense, and when that right of private defense is being exercised by you, right? Now, coming to your next section, I have skipped one section and I will deal with it later after this section. We have come to now the main core section of private defense, where we get to know what are the limitations of private defense, right? Now, the section starts on a negative note. It says that there is no right of private defense against an act which does not reasonably cause apprehension of death or grievous hurt, if done or attempted to be done by a public servant acting in good faith under color of his office, though that act may not be strictly justifiable by law. Lot of concepts in one small para. Let us look at it again. You do not have a right of private defense where if an act is done or attempted to be done by whom? A public servant, right? He must be acting in good faith. So his mental element is told to you. Under color of his office. Now, what does this mean? He must be acting under the color of his office. Now, public servant is a term defined under IPC, and there are large bulk of people who may come under the ambit of public servant. If such an individual is acting in good faith and acting under the color of his office, means he is acting under the if you've seen a shade card, if you used paints, when your house is painted you see a shade card. If you are under the ambit of the color of that office, for example, and it's a silly example, if I take green and then there are so many shades of green, which means it's green, but there's light green, there's dark green, etc. And that's what the legislation is so beautifully trying to tell you, that it is, if the act is within his color of office, it is at its essence coming within that shade card, then though that act may not be strictly justifiable by law, he may not be justified, it may not necessarily be justified by him by law, but because he is acting in good faith, he's doing it in the color of his office, he, even if he may not be justified by law, you don't have a right of private defense in such limited circumstances. What are the circumstances? Public servant working in good faith in the color of his office. In those situations, you don't have a right of private defense against him. But again, there is also to this an exception. What is it? The first line, an act which does not reasonably cause the apprehension of death or grievous hurt. It should be such an act by him that it does not create a fear in you of death or grievous hurt. In all other situations, that particular public servant, you don't have the right of private defense. But here also, the exception is clarified. It states that only in those circumstances where he's doing an action which does not amount to death or grievous hurt, you can't use your right of private defense. But if you have an apprehension of death or grievous hurt, then probably the section states that this limitation on you will not be there. The limitation is only in all other such circumstances, by him, a public servant in good faith, acting in the color of office. Right? Now, I have switched the sections up a bit. I have brought the explanation relevant to this part close to it so you understand better. Now, what is the explanation to this part? The legislation says a person is not deprived of the right of private defense against an act done or attempt to be done by a public servant as such, unless he knows or has reason to believe that the person doing the act is such public servant. So the only time he doesn't have a right is when he knows that the person who is doing that act is a public servant, right? If he doesn't know and tries to save himself, that right is available to him. So this explanation clarifies that in some way the individual involved must know that the person who's carrying out that action is a public servant and is acting within, in the color of his office. If you don't know, that right of private defense continues. Now, another extension to the same section states that against an act which does not reasonably cause the apprehension of death or of grievous hurt, same line repeated, if done or attempted to be done by the direction of a public servant acting in good faith under color of his office, though that direction may not be strictly justifiable by law. What has happened here? There, the person, the public servant, has clearly stated that he's in the color of his office doing an act in good faith. Here, another individual who is under the direction of a public servant in good faith, under the color of the office of that public servant, is doing an action, right? So If the Public Servants Act is protected, any person doing an act under his direction is also protected from our actions of private defense. But again, there is an explanation here. A person is not deprived of the right of private defense against an act done or attempted to be done by the direction of a public servant unless he knows or has reason to believe that the person doing the act is acting by such direction, or unless such person states the authority under which he acts, or if he has an authority in writing, unless he produces such authority. So again, same thing. If you know the person is a public servant, then against his act, you don't have a right of private defense. If a person is acting under the direction of a public servant and he is mentioning that, or he's stating the authority of that individual, or if he has something in writing, produces that particular thing, then in that situation, you don't have a right of private defense against those individuals. But if you don't know, if he has not stated who he is and he's doing an act, and then in that scenario, because you don't know who he is, you will continue to defend yourself. Only when you know that they are doing an action under the direction of a public servant, then you are expected not to use your right of private defense against such an individual. But again, in both of these sections, what we see is that it does not extend to death and grievous hurt. So if any act done by them creates a risk or a threat of death or grievous hurt, your private defense rights come back, right? Only when in any other action, if they their use their powers as public servants to act in a certain way in good faith, in color of office, then you don't have a right of private defense, right? Moving further, we do not have the right of private defense in cases which there is time to have recourse to the protection of public authorities. So, if you remember, when I started out this discussion, at that time also, what I had mentioned is, as per se, as a rule, it is the state which takes care of our justice system, right? And it is the one who will take care of all wrongs that are done to us. But we get the right to private defense only when there is no recourse to them. If there is a recourse available to them, then our right to private defense does not exist, is not required simply, right? So when there is recourse to public authorities, in those situations we don't have right to private defense. When there is no recourse available, there is no time for that recourse, then the right of private defense comes into picture. The right of private defense in no case extends to the inflicting of more harm than it is necessary to inflict for the purpose of defense. So the section is trying to hint at something known as proportionality. The amount of harm that you're going to face, the harm that you cause in order to defend yourself, also should try to be proportionate. Now, when we saw the James Martin case, we see that these two individuals are in such a stressful situation. Some would even say that their response was a little heavy, where two people have passed away, right? So it's very difficult for us to identify in what situations how much is proportionate, right? When we are in situations of great stress, proportionality is a very difficult thing. So we see that the court has very eloquently in different judgments tried to identify what are situations where you have exceeded the right of private defense. And sometimes it has exceeded to such an extent that it is no more private defense and it has become something else. And we will be discussing that in the future. But for now, what you must understand is, if somebody is going to harm you, your your defense is just an act of preservation, not harm. So you will only cause that much proportionate harm, or try to cause that much harm only, which is, or to protect yourself, to preserve yourself, and to defend yourself. It is, as we discussed, a defensive right. So proportionate harm is the last thing that is incorporated in the section. Primarily, we understood that public servants have some protections, and we have limited private defense against them. Then we understood that if we have recourse to public authorities, then the right of private defense does not exist. And lastly, that it is expected that if you do utilize your right of private defense, it has to be proportionate in nature. Okay. Now we come to another landmark judgment which was passed, and this deals with multiple facets of the right of private defense. Before we go into the case and look into the judgment, let us discuss the facts of this particular case. So, what are the facts of the case are, let us say, there are two parties, right? Now, again, there is a feud between these two parties relating to property. And one day, there becomes some kind of skirmish between these two people, right? Now, these two were armed. Armed means one had a sharp weapon and the other had a gun or a pistol, right? They are armed. These two may have had something, but what they had was heavier, sharper, more lethal, one would say, right? Now, because there is some kind of work which B's group is doing on their plot or their field, and which is adjacent to A's field, then in that situation, some skirmish happens between these two groups. What is seen is that between this skirmish, A shoots B. A had the gun, he shoots B. A is saying, I utilize the right of private defense because B and B's group were also creating an altercation between us. Now, what are the different facets? And an important fact which I have also highlighted in the case is that they were in different large fields, but we see that it was B's side of the group which had entered into A side of the field and were, in his field having whatever altercation that they were having, right? And another important facet is also this, that this was relating to some ridges which were being made on the fields which had this, common area. Now, it was said by A's group that their ridges were damaged. So they are saying their ridges are damaged. They are also saying that this entire group had come there, especially this person B. Now we will have a look at the case. So this is a set of facts of the case. As I have already told you, they were having an altercation. So the two people on the other side were named Bhaktavar and Darshan. Darshan was the one who shot somebody from the A group. Now, before we go further, let us look into this aspect and we'll discuss this. A man is justified in resisting by force anyone who manifestly intends and endeavors by or surprise, violence or surprise to commit a known felony against either his person, habitation, or property. In these cases, he is not obliged to retreat. This is important. He is not obliged to retreat and may not merely resist the attack where he stands, but may indeed pursue his adversary until the danger is ended. And if in a conflict between them he happens to kill his attacker, such killing is justifiable. Now, why is this important? Because there are certain rules which state that if you as an individual are in the face of some harm or wrongdoing, then the first thing that you should do is try to retreat, meaning run away from it. Now, what we are seeing in this judgment is what is the opinion of the court. What does our court think? What does our Supreme Court think? That when we as citizens are faced with difficulty, how should we respond? So the court is citing paras, and you can see here the court is trying to say that one must not retreat. You are not obliged to retreat. You must not leave and run. In fact, you may try to defend yourself. So we can now understand the Supreme Court's mindset when we talk about um, private defense. They say that don't retreat. That rule is there. But in India, our courts, what they are trying to say is that you must exercise of your right of private defense. You must not retreat. It is repeated here that the court repeatedly has observed that there is nothing more degrading to the human spirit than to run away in face of danger. The right of private defense is thus designed to serve a social purpose and deserves to be fostered within the prescribed limits. Hari Singh Gaur, in his celebrated book, aptly observed that self-help is the first rule of criminal law. It still remains a rule, though in process of time, much attenuated by considerations of necessity, humanity, and social order. According to Bentham, in his book, Principle of Penal Laws, has observed that the right of private defense is absolutely necessary. It is based on the cardinal principle that it is the duty of man to help himself. So we see why this is very relevant. You must understand is that this is a question asked to you in your papers. There is this rule of retreat, and our court is saying you must not retreat. In fact, it is required for you to stay. They say that it is one of the first criminal principles of criminal law that we must try and defend ourselves. The Indian Penal Code defines homicide in self defense as a form of substantive right, and therefore, save and accept the restrictions imposed by the code, it seems that the special rule of English law as to the duty of retreating will have no application to this country where there is a real need for defending oneself against deadly assaults. This is extremely important. The cases have come on this, that does the English law as to the duty of retreating is applicable in India, and what is the mindset in India towards this particular rule? Answer is no. We do not believe in this rule. We believe in defending ourselves. So, again, they reiterated the citizens, as a general rule, are neither expected to run away for safety when faced with grave and imminent danger to their person or property as a result of unlawful aggression, nor are they expected by use of force to right the wrong done to them or to punish the wrongdoer for commission of an offense. So, neither are you supposed to do something too much, but neither are you expected to run away in the face of danger. You are expected to defend yourself, right? Now, we have understood that the court has spoken about the right of private defense and that we must exercise it. We must not retreat, we must exercise it. But now, this debate comes in is that sometimes when people exercise the right of private defense, excessive harm can be caused, right? So, whether we look at the James Martin case or the Darshan Singh case, what do we see? That in this case, Darshan Singh has killed another individual, right? There is a death, and then there is this concern that is this exceeding your right to private defense? Are you doing too much harm in context of the harm that you received, right? In the garb of private defense, are you causing excessive harm, right? So the court answered to this question. It stated that the person in fear of his life is not expected to modulate his defense step by step or tier by tier. Justice Holmes, in the aforementioned case, aptly observed detached reflection cannot be demanded in the presence of an uplifted knife. It's so beautifully written. When there is a knife in front of you, you cannot expect a person to be very balanced and think how much force he is going to use, right? While we expect proportionality, is it really possible for a person who is in such a threatening situation to think very, in a very balanced manner? Of course, you are under pressure. So there is chances that you cannot look at it so microscopically. You can't look at the harm which you do or the act that you do during your act of private defense very microscopically, because you are also just responding at that moment to whatever harm that you are receiving. And this important para, because again comes as a question in your mains papers and also has been asked in MCQs also. According to section 99 IPC, the injury which is inflicted by the person exercising the right should be commensurate with the injury with which he is threatened. At the same time, it is difficult to expect from a person exercising this right in good faith to weigh with golden scales what maximum amount of force is necessary to keep within the right. Every reasonable allowance should be made for the bona fide defender, right? The courts in one voice have said that it would be wholly unrealistic to expect of a person under assault to modulate his defense step by step according to attack. So, this word with golden scales, meaning you can't with so much, uh, you know, detail look into how much force was used. You must bear in mind what situation this person is in, and they use the word bona fide defender. If somebody is truly under threat and under real threat, we cannot look into minute details of how proportionate it should be, exactly proportionate, right? Those questions were some things which in this case the court is trying to explain. And again, this term golden scales can come in the paper. All it's trying to identify is that in situations where you're exercising your right of private defense, while you must be proportionate, the court understands that in such situations it cannot be exactly proportionate. There can be some kind of mismatch which may be there in the amount of force used. Now, this is the fact which finally gives us the answer to this case. Gurcharan Singh gave a Gandasa blow, hitting my father Bhaktavar Singh on the head as a result. This is Darshan Singh speaking. He's saying that Gurcharan Singh, the A group, gave a blow hitting my father Bhaktavar Singh, B group, as a result of which he fell down. I felt that my father had been killed. Gurcharan Singh then advanced towards me holding the Gandasa. I apprehended that I too would be killed, and I then pulled the trigger of my gun in self defense. So he's saying that, you know, the A group, they came there, and he had first hit his father who fell down. And after seeing his father fall down, he felt his father has passed away. And as Gurcharan was coming towards him, he used his gun and, as an act of self defense, tried to protect himself. Court has held in the facts and circumstances of this case, appellant Darshan Singh had the serious apprehension of death or at least grievous hurt when he exercised his right of private defense. So the court acknowledges and accepts the fact that he is having the right of private defense, and what he did was to save himself, right? Another thing that the reason I have highlighted is it is very well written. The legal position, and it is cited multiple cases, the legal position which has been crystallized from a large number of cases is that law does not require a citizen, however law abiding he may be, to behave like a coward on any occasion. So they want us to preserve ourselves, to defend ourselves. You know, they don't want us to act like cowards. All right. So with this, we have understood that the court gave the right of private defense, and it also gave certain principles, important principles of right of private defense. Most of them we have discussed, but we will quickly give it a read. Self-preservation is a basic human instinct and is duly recognized by criminal jurisprudence. Again, we had a discussion on this. The right of private defense is available only to one who is suddenly confronted with the necessity. So there is this doctrine of necessity which comes in, that you have no option but to avoid danger by defending yourself, right? You don't create the harm. There is a harm coming to you and you defend yourself as an act of necessity. A mere reasonable apprehension is enough to put the right of self-defense into operations. It is not necessary that there should be an actual commission of the offense in order to give rise. right? So even if you just feel that something is going to happen to you, even if there is this um, inkling and you feel that there is a threat, not necessary that something must be done, but there must be the reasonable apprehension that something might happen. The right of private defense commences as soon as a reasonable apprehension arises and is coterminous with the duration of such apprehension, right? So your right of private defense starts as soon as you feel this fear that something is seriously going to happen to you. There is a serious threat that is happening to you. So they stand side by side. Your private defense right starts as soon as you feel the apprehension. It is unrealistic to expect a person under assault to modulate his defense step by step with arithmetical exactitude. So the court is again saying that it's not possible to expect exact force, the amount of harm that the front party is doing, that much exact arithmetical exactitude cannot be expected. In private defense, the force used by the accused ought not to be wholly disproportionate or much greater, but they still say that it should not be completely disproportionate. It is well settled that even if the accused does not plead self defense, it is open to consider such a plea if the same arises from material on record. Again, I had mentioned this, that the court can also take cognizance. The accused need not prove the existence of right of private defense beyond reasonable doubt. Again, we had discussed this, right? As soon as there is a preponderance of probability, it has more or less helped in establishing the case. The IPC confers the right of private defense only when that act is unlawful or wrongful. Wrongful act is an offense. Important part is that it must be an offense against which you are using your right of private defense. A person who is in imminent and reasonable danger of losing his life or limb may, in exercise of self defense, inflict any harm extending to death on his assailant, either when the assault is attempted or directly threatened. Right? So you can even go to the extent of causing the death of an individual. This is further dealt with me in the next part when we deal with specific sections. Just highlighted the final part of this judgment that Darshan Singh was acquitted, right? Whatever was the decision of the trial court was restored, which is the acquittal of Darshan Singh. So, from this case, again, we realize that there may be situations where we feel that the right of private defense has been too extensive, but one realizes that when private defense is exercised, it cannot be expected that it is completely exact. The amount of force used in order to protect yourself is completely exactly in uh, balance with the harm that you were expecting, right? So Darshan Singh, as I said, the principles of private defense, we just had a look at that. The concept of weighing in golden scales, the harm that the person was trying to threaten you with, and the amount which you use in order to defend yourself, it cannot be weighed in golden scales. And then lastly, the rule of retreat to the wall. It is not expected from us in India to retreat in the face of a threat. We are in fact expected to defend ourselves. If you remember in the start, there was a hint in the Surjit Singh case that it is not only a right, but it may also be a duty to preserve ourselves, right? Just wanted to highlight that in when we deal with the concept of murder, in fact, there is an exception which states that if a person exceeds his right of private defense and causes the death of an individual, and if it was the right of private defense which caused that passing and it is an exceeding of private defense, it will not be treated as murder, it will be treated as culpable homicide. Coming to the last section that I will be dealing with today, as I had said, I had switched the sections. So, this section is a discussion which is very interesting. Why is this interesting? Because what will happen in case where somebody who is of unsound mind is going to commit, is threatening to commit something to you, can you exercise your private defense right? Now, you will say, of course, I have the right to self preservation, which is fair, but you have to look at it legally. Now, if you remember when we were discussing what is the right of private defense, that where an individual protects himself against an offense, either of the body or of property, right? His or any others. You have to protect yourself or any other person against any offenses of body or of property. Now, the problem is when an individual is of unsound mind, or if a person is not old enough, that is, a young individual, or does not have understanding or intoxicated, these people cannot commit offense. All their actions are protected, right? If you study, if you've been a part of my previous lecture, we just studied that if an individual is of unsound mind, then his actions are not an offense because they are protected. So if there is no offense, then how can you defend? So interestingly, I find it very interesting that how the legislation thinks of everything, and the legislation clarifies that yes, their action is not an offense. But even in this scenario, while their action may not be considered an offense, but your right to defend yourself from their action continues. Just to clarify, because they have stated an offense is required for there to be a defense in these scenarios where an offense cannot be created, because these individuals come under general, exceptions, they're protected. Your right to defend continues even against these individuals. So just a quick reading to this is: when an act which would otherwise be a certain offense is not an offense by reason of youth, the want of maturity or understanding, the unsoundness of mind, or the intoxication of the person doing that act, or by reason of any misconception on the part of that person, every person has the same right of private defense against that act, which he would have had if that act were that offense. So the only reason the action is not an offense is because it is committed by individuals who are protected, right? So while they are protected, they are under the exceptions, you still continue to have your right of private defense against them. You can still try to defend yourself. So again, it comes back to the right of self preservation. You are not causing harm, you are expected to do an act which is to preserve yourself. So that right continues even though there is no offense technically committed here, because the people doing the action are under the exception, right? Just taking one illustration from this: Z, a person of unsound mind, attempts to kill Z, to kill A. Z is guilty of no offense. He is protected. But A has the same right of private defense which he would have if Z were sane. So your right continues, right? Even if Z is guilty of no offense, your right continues against him. Lastly, we will just have a look at some of the questions that have come up, and that based on these reading of these questions, I have tried to orient my lecture. Private defense is very vast, but I've tried to deal with things which would be helpful to you. So this question has come in: right of self-defense cannot be measured in golden scales. Elaborate. A very deep understanding of what is private defense will help you answer this question. Private defense is not available for retaliation, but for averting the danger which is not created for himself. So it is not a right of retaliating, it is a right of defending. Okay. Discuss the relevance or otherwise of the concept of retreat of the wall in the exercise of private defense. It has come in the DJS papers. So retreat to the wall not applicable in India, right? What is the concept? and whether it is exercised in our country will be something you must mention. A was under attack from B. A had ample opportunity to save himself by fleeing away, but instead A defended himself and thereby caused harm to B. Is it a valid exercise to the right of private defense? If you see, I consistently and repeatedly read, and one of the lines which stands out is that the the law doesn't expect you to be a coward, right? So this is a hint, and this can be a very good answer that you write if you understood the concept that we were trying to understand. Private defense, very beautifully, in India, is a right which is not only provided to us, it is expected out of us to be done, right? We are not expected to retreat, we are expected to defend. So with this, I come to the end of my lecture and I do a short recap. We started with what is the right of private defense. We understood that it is a defensive right. We understood the fact that this particular right has, its constitutional validity also, and in fact, it brings a lot of facets within it. In the James Martin case, also, is what we understood. Um, we then had a discussion as to how it splits into two halves. We also discussed the burden of proof, the concept of preponderance of possibilities, and after splitting, we also saw that how it is important that there should be an offense involved and how they are of certain kinds when it deals with the private defense of property, how possession plays an important role, right? Then we move on to the limitations on private defense which have been created. And as I said, public servants create a limitation on a right of private defense. Where you have recourse to public authorities, there is the right of private defense which is limited, right? You cannot use it. And then you cannot inflict more harm. So the concept of proportionality came in. We dealt with the Darshan Singh case quite quickly, where we discussed the principle, the concept of weighing in golden scales, the rule of retreat to the wall. We discussed that there is also some conversation under the exceptions to murder of exceeding of private defense. We discussed how a person who himself may not be guilty of an offense, if he commits some kind of threat to you or some harm to you, your right of defense continues. And we have simultaneously looked into some MCQs and mains questions that have been asked to you in your papers. I hope that I have been able to answer some of your doubts or clear some of your doubts with regards to the right of private defense. This is my first part. The second part goes deeper into how the right of private defense is available when it comes to the body of an individual and the property of an individual. So you can join me tomorrow in case you're interested in finding out further how the right of private defense works out. In case you have any queries regarding this lecture, please do comment and I'll try to answer those questions. Thank you so much for joining me.
मेरा जो वहाँ पर सुझाव था बच्चों को, सिर्फ धरना देने से नहीं होगा, हम लोग आपको सरकार से बातचीत